So I want to welcome everybody back. So again, you know the introduction of Mark Lemley. If you don't recognize him by now, I can't help you. But somebody that I'm excited to have here for the first time, Molly Kocialski. Molly and I go way back. She hired me as a trial lawyer 22, 3, 4 years ago. That's how I got to know her. And then we worked together at the USPTO, me out here, and she was actually the one training me. But Molly spent almost a decade as the director for the Denver Patent Office. I like to say that Molly resigned. Now she's at Holland Hart. And instead of trying to replace her, they just closed the office down. So I'll let Molly describe if that process that I'm laying out is exactly right. But that's what I'm going to tell. So with these two, you have some different views and some similar views. So we'll let them go. Please ask questions and press on the differences between the opinions.
Well, we might or might not have different opinions on some of the issues here. We're gonna talk about the aspirational title "Making Sense of the USPTO" might not, in fact, be achieved. In the 1960s, in the NASA space program, some engineers came up with the term "rapid unscheduled disassembly" to describe a rocket suddenly exploding in the middle of space. I think we are watching the rapid unscheduled disassembly of the U.S. Patent and Trademark Office, and I want to talk about some of the sort of the issues, and we're going to break this into kind of like 4 or 5 basic parts. So I want to talk about sort of the people, the personnel, what's actually going on with the people inside the office right now. We're going to hear a lot from Molly on that. We're going to hear about sort of changes to the examination process, what's happening, what might be coming in the future, and Molly, again, will take the lead on that. We're going to talk about some things you've already heard today and yesterday, which is some of the kind of comprehensive guide to what's going on in the IPR process, and I'll take the lead there. And then we'll talk about the sort of broader picture outside the PTO of the administration's policies towards patents and innovation. And then finally, I think we want to bring it back to sort of, okay, here's a bunch of things going on in the patent office, in the broader administration. Why should you care as prosecutors, right? And how does this affect you? So all right, so why don't we start, Molly, with people, and we'll start with you. As Wayne mentioned, right, you until recently headed the Denver Regional Patent Office. Mm-hmm. You have left that position, and in fact, there is no longer a Denver Regional Patent Office. Tell us a little bit about that.
Yeah, so it was actually not. Everyone has asked me, it's like, did you know that was going to happen when you left? And in gaming out what might happen in possible scenarios, it was definitely a thought process, especially since my boss's boss, acting director Stewart at the time, had said in a town hall where I don't think that she knew that we were present, that she didn't know what we did and that our offices were really expensive to run. That's a direct quote. So kind of the writing was on the wall there, like maybe what I do isn't valued by the agency anymore. And so that was, at least one of the causes. There were several other causes of why I left. I will say that almost every action that they have taken with respect to the USPTO and its personnel, one of the things that made the agency the best place I have ever worked, and I have worked at some phenomenal places. I've been very blessed in that perspective, but it was the people, and it was the way that the agency treated its people. We always put them first. I think there's a quote in Patricia Duffy's affidavit in the union lawsuit that is really quite, it actually just summarizes why we were that. With the goal of wanting to retain skilled employees, the agency, in dealing with unsuccessful employee, weighed affording a limited time to show that they can yet again perform. If you terminate and hire a brand new employee at a lower level, who for years will need much more management oversight and resources, and who will take years to get to the same level as the terminated experienced examiner, right? We really put the people first. And literally every action that they have taken, from return to office, no other time for training, contact contract cancellations, firing probationary examiners without cause, creating non-bargaining examiners, mandatory days of connection where they bring everybody on TEEP back to Alexandria at their own expense. There's just every single action has been taken as the antithesis of what I was always taught as a leader in the federal government, which was to put my people first.
So let's try to break down there's a lot on that list.
There's a lot of, I didn't even mention the breakup of the union.
There's more. We'll get there, right. But let me start with the sort of, so that we closed the Denver office. We don't know what they're doing. It's expensive to run. But we also have a return to office mandate, don't we? Or at least in part. So what does it mean to return to office at the USPTO?
Yeah, unsure. I guess if you're within 50 miles of San Jose, Dallas, or Detroit, that means you're still going into an office. But for the Denver employees, they actually got to go work from home. What was interesting, of course, was also the data that they used in determining to close the office. They used a December 24 report that said that there were only 10 employees coming to an office. So they used a report from before there was the return to office mandate in order to justify closing the office.
And then
make it make sense.
And then, well, so and return to office, at least at the outset, applies not to the patent examining corps because
Correct.
They have a union contract that allows them to work from home. Had. Well, we'll see. We'll get there in just a minute, right? But applies presumably to everyone else. But, right, one of the things that the Trump administration did this summer was to declare that it was breaking the union of examiners, POPA, because patent examiners were critical to national security, and you couldn't have a union for people critical to national security.
Yeah, that was actually a surprise for a lot of people. So I believe there's maybe 24 people in the entirety of the U.S. Patent and Trademark Office that hold a security clearance that is above a person of trust. And just for all of you to level set, janitors in federal government agencies have a security clearance of a level of person of trust. So, right, like, and you only really have 24 people, and a lot of them aren't even in the examining corps. They were in, kind of the pre-exam formalities and reviews, and then they were also in OPIA and OPLA, OPIA being the Office of Policy and International Affairs and the Office of Patent Legal Administration. And they were the people who were responsible for reviewing national security applications. There is no training that goes on for your run-of-the-mill examiner about what to do if they think that they have an application in front of them that has national security implications. They have no process in place to make them, kind of be able to raise their hand and say, I think this is a problem. And they've never been trained on it. And as at least the 112 panel this morning said, right, the one thing the agency used to be really good at is training its employees as well as making that training available to all of you. One of the other changes that they made over the course of the last 9 months is 10 months, is that there is no more other time for training. So when the examiners take a training, it is in their free time. It's voluntary.
So is it, my instinct is this is pretextual, right? We're not desperate to make sure that that we're protecting national security. Now we can make people return to an office. They can't work from home. Maybe we can change their working conditions or their quotas.
And that's exactly what they did, right? And so for at least the examiners, they made a number of changes to the examiner performance agreement back in early October and started communicating those out. I'm sure everybody has seen, right, like a lot of the angst online about that. But let me put it in pretty stark terms for you, and just in terms of one of the changes that they made to the PAP. So, right, prior to this year, to be fully successful in the federal government as an examiner, you had to achieve a 95% production rate. And the 95% was based on what you could do in terms of your service grade, your technology area and what you were, like, what the expectation was. And we set it at 95% because it's a hard job, right? Most examiners are really one big life event away from not making that 95%. And that was true for years before. You know, if you had a death in the family or you had an illness or something like that, you got in a hole pretty quick. And it was one of the reasons why the agency was able to say that we were able to do telework, because we knew within a bye week whenever an examiner was off the rails, because we would see their production go down. And so I think, right, like 95% was one thing. It allowed the examiners some flexibility, some work-life balance, all of those other things. They changed that to 100% without actually recognizing what that means for an examiner. But basically, they're asking each and every examiner to add about 6 weeks of extra work to their docket in order to become fully successful now. And if they're not fully successful, the removal of the union also means that they don't have a union rep that's going to help them negotiate a performance improvement plan. In addition to all of that, the Office of Personnel Management has said, hey, guess what? We want to make sure that if someone's on a performance improvement plan, they have a very limited time to come off of that performance improvement plan. And so the Office of Personnel Management has strongly suggested that no performance improvement plan should last longer than 60 days. There is not an examiner. I know I couldn't dig myself out of a production hole if I needed to in 60 days. So I think one of the things that will be the result, and we'll start seeing this in April at mid-years, is a result that there are going to be a number of examiners that are going to be put on performance improvement plans. And then I think we'll see a further attrition of examiners starting like that April, May, June timeframe. So it is really important to, you know, kind of look at that. In addition, if you look at like what has happened from an attrition level with all of the other actions that the administration has taken, fork in the road, the voluntary early retirement authority, the voluntary incentive separation payment, all of that.
Hiring freeze outside.
The hiring freeze outside, well, for 8 months, it was a hiring freeze full stop. And then they only became able to, really start hiring again in August. When they did start hiring again in August, they changed the rules about what was hiring. So anyone hired from August to, well, whenever, they are hired under the authority that they can only reach a GS 13 perspective, which means they can never become a primary. Primaries are where the office makes their money. Those are the workhorses. That, the goal in the past was always to get an examiner from a GS 7 or a GS 9 position into a primary position where they were signing their own cases. And that has changed. They are not eligible for telework. They have to be in person, and they can only reach a GS 13, which will then obviously limit the pipeline for people who become primaries, and then also for people who will become SPs, because you don't become a SP unless you are a primary.
So is the idea that they're going to just phase primaries and SPs out altogether? But I don't even know how that would work if a non-primary has to have a second sign-off by a primary.
Even the primaries right now are having to post all of their first office actions on the merits to their SPs. And the SP has to sign off on any allowance, which inevitably means, right, like there's a bottleneck. When you've got a SP who's got somewhere north of 13, 14, 15, if they have 17, or if they're in a super group, where they have like 20 people reporting to them. Each one of those primaries generates a first office action on the merits to the tune of about 4 to 6 a week. So you do the math.
I like the concept of an examiner supergroup. I'm envisioning like 1970s rock band.
Yeah, no. Although there are some groups in the agency that do have very strong karaoke game, I have to say. The Patent Trial and Appeal Board judges have a very strong karaoke game. And the former Office of Education and Outreach, they even had a dance routine. So I'm just saying, there's some strong karaoke game there.
All right, so nonetheless, we no longer have a hiring freeze. We can, in theory, hire. It's maybe a less attractive job. It doesn't have a promotion ability, but so the PTO is now trying to hire examiners, right?
Mm-hmm.
How's that going?
Not so well. They wanted to hire 800 before the October 1st, changeover from the fiscal year. I believe the number was somewhere around 250, maybe 300 that they managed to get in the door. That is not going well. For at least the August class, I understand that the attrition rate is somewhere north of 70% at this point. And the attrition rate for first-year examiners was always horrendous, right? Like it was always around 50%, right? So, it's 70% isn't that shocking to me, but it is relatively shocking. I think the problem with that is also that they changed how the examiners are being trained. So prior to this administration, examiners would come in, they would receive 4 months of training in an academy altogether. They would stay with that academy group while also starting to work with their SPEs a little bit over the first year. And then they would transfer out to their SPEs and their art units after their probationary year. But they had guide rails, they had mentors, they had people who were able to answer all of I'll just call them the silly questions, right? What do I do about this? And you had some cross technology areas that really, I think, made examination better. That has changed. They get 6 weeks of classroom training that is mostly video now, and they are immediately assigned on day one to their SPEs. And so now, not only are the SPEs having to do first office action on the merits reviews, allowance reviews, for all of their primaries and even their juniors, right? They always had to do it for the juniors, but they're having to do it for the primaries now. But in addition, now they have all of the mentoring, all of the training, all of the hand-holding of what I like to refer to as baby examiners. And they do need a lot more. In addition, they cut off the other time for the primaries to help. So in the past, right, SPEs could count on primaries to help the juniors sign. That is no longer able to happen. The primaries cannot get any other time for helping juniors along. And so that aspect of mentoring and bringing the baby examiners along is gone. So it's all on the SPEs.
Now, say something about the new performance review or proposed performance review process.
So they really got the rug pulled out from under them. In July, August timeframe, the Office of Personnel Management announced that they wanted to be grading on a curve. So only 5% of any personnel in any agency could be outstanding. Less than 20% could be commendable. The rest had to be fully successful, or people needed to be put, if they weren't making their numbers, they needed to be put on a performance improvement plan to be marginal, or I don't even remember what the one is, but it's bad. And that was supposed to go into effect for FY26. So that would have gone into effect starting October 1st of this year. Instead, the agency elected to apply it to every person in the agency for last year's performance. And they made that decision in August. So you had people who had been outstanding for their entire career. And it affected, I think, people like SPEs and people who were in support organizations like quality assurance specialists, the judges, any of those. You had people who have been outstanding for their entire careers. And mind you, there's a bonus number that's tied to the outstanding level. And all of a sudden, they're fully successful. And for a lot of the SPEs, that meant that they didn't even get a bonus this year. So you've had their work, these SPEs have had their workload double at a minimum. And then they're not getting a bonus for doing what they're supposed to be doing.
Well, so hopefully we've sold you on the possibility that you want to apply as an examiner. Let me raise one final thing as you file your application for the examiner, and that is the Donald Trump loyalty oath. So
just in case anybody doubts, I actually brought the performance agreement that they wanted me to sign, which was one of the precipitating factors to me leaving, with me to show you. The first critical element of my performance agreement was faithful implementation of the administration's priorities.
I will note, if you are an applicant rather than simply someone who is already working in the office, this is true throughout the U.S. government, not just the Patent Office. On the applications for civil service positions, which are by law nonpartisan positions, one of the questions asked is, tell us what your favorite Donald Trump executive order is and why. I am not making this up.
Yes.
So, how's morale at the Patent Office?
Let's see, which it's horrible. And again, right, like, I mean, it is just every action that they are taking is the antithesis of what we were taught to do as federal government leaders. And so, yes, I don't know of any person there who feels like they are valued, that the work that they do is worthwhile. They are disconnected from the mission and the vision. I think there are a couple of things in the patent examiners subreddit feed that are, I feel, pure comedy gold. There is someone who is acting as an AI scout who's the new cheerleader for the administration. That is pure comedy gold. I highly recommend going to read it. But there's, I think, a lot of anger. I also think, there's a lot of recognition, especially for the examiners who have been there for a long time, that, the relationship between corporations, the USPTO, and law firms is a very symbiotic one. And I have to tell you, what happens to symbiotic, organisms when one part of them is literally bleeding out? It's going to affect all of us in some manner or another over the course of I would say, the next year. And the worst part about all of this is it has all happened in the last 10 months, right? Like it is, and the pace of change just keeps happening. And it would be one thing if it was just POPA, right, with the union aspect of it, but they actually got rid of the NTEU 243, which covered all of the legal instrument examiners, all of the support staff along those lines, and they brought those people back to the office. So while they aren't bringing the examiners back yet, and I do use the word yet, they have brought back a lot of people, which has led to even more attrition in some of those places. So you are probably seeing
in force outside the examining court, right?
Yeah. So outside of the other thing that they did on October 1st was they announced a reduction in force. Now this has been reversed because the court told the administration that was illegal. So they have actually brought back all of the people that they reduced in force on October 1st. But they laid off about 220 people. And if you read the messaging of the agency, and so maybe this is a pro tip for you as you're taking it away, dig deeper into the messaging of the agency and understand what they're really saying. So the messaging of the agency was that it was just a 1% reduction in the workforce. Well, that's not really true. Because what they did for the reduction in force is everybody who was a patent examiner, everybody who was a trademark examining attorney, and their direct supervisors were exempted from being considered for the reduction in force. So those 220 people came from the remaining aspect of the agency. So you had a reduction in force of 220 people out of 4,000. Which is more like a 20% effect. 50 of those people came from CIO. I don't know about all of you, but I rely heavily on the IT. So do the examiners. And so there's, they can't even get DAV or Palm to work at a 99% rate right now. So good luck employing an AI tool that's going to crash the systems.
Question in the back. You got a microphone coming to you.
Yeah. Please, it's on.
Wanted some audience participation. So my question to you is, Molly, in your view, why is this being done?
I have a theory too, but
Yeah. I want to hear yours.
Mine
is bleak.
Well, I mean, some of it is just some of it is chaos, right? Some of this is broader administration, OPM dictates. Everybody must come back to the office. Everybody must write us an email every week telling us what 5 things they have accomplished for the government.
Which,
right?
by the way, the USPTO is the only agency that's still doing that.
Oh, is it right?
Yep.
Interesting.
Only agency.
The loyalty oath, a bunch of this stuff is Trump administration priorities that come from outside that are, and the patent office are sort of casualties of it. But I also think there's another thing going on, and we'll talk a little bit about this as we shift to kind of the changes in the examination process. I think there is a view in the leadership that 3 years from now, we're not going to need examiners. AI is going to do everything. We're already trying to push AI search. I think the reason we don't have a promotion category for the new people we're hiring is we don't think we're going to need primary examiners and SPs down the line. We don't want to give people a long-term job prospect because we think we're going to replace you all with AI. I think that's going to work about as well as you expect it will work, but that's my guess. I can't prove that. I don't know, Mother. You may have a different theory.
And I might actually piggyback a little bit on, the notion that OPM is driving. So, right, OPM has been very clear about its opinion of federal government workers. I think some of the terms that especially Russ Vought has used for federal workers is that they're lazy, they're undedicated, they're just milking the system, all of those other things. So I think some of those biases are there. I will say, in the first Trump administration, the USPTO was held out as the example of what agencies should be. Fully user fee funded. We were able to keep track of our people, and even if they worked from home, like I said, within a bye week, we know when someone's off the rails. We can prove, right, that people are doing the work of the agency even when they are working from home. And I still say we. I really have to get over that. But right, like we were held out as the example of what an agency should be. And so to me, having had all of these things be applied to an agency that was functioning, that was efficient, that was effective, and that supports 40% of the U.S. GDP is nothing short of tragic and wasteful.
All right, so maybe you're thinking, I feel really bad for the people at the PTO, but how does this affect my life? So why don't we shift from kind of internal PTO to think about sort of examination, right?
Okay.
So you mentioned already some of the changes to the examination process, right? The
First office action on the merits on the review, right?
Yeah. Okay. So right. So there's one big change already, right? So what does that mean in practice? The examiner now, even my primary examiner can't sign off on something.
Yep.
Okay. That sounds like another layer of process.
That's a bobottleneck. For sure,
right? Is it? I mean, is it changing anything? Is it not? Are they getting? Are the SPs actually overruling the primaries?
Yes.
Okay.
Yeah. And so it's called a streamlined review. So if you see that word used somewhere,
Then that's how we know there's more process.
more process.
Okay.
And the SPs are returning errors back to the examiners, even the primaries. What it means is more time between when the examiner is able to issue, kind of do the office action and when you actually receive it in the mail. And so one of the things, that they've touted all along as this emergency is the backlog. And then in August and September, they took credit for reducing the backlog below 800,000. Well, I have to tell you, as of the USPTO's own numbers for the end of October, they are back up to 791,173. They will be over 800,000 by the time we get to the end of this year. So they are not reducing the backlog. That is not good. The other numbers that you need to really pay attention to is first action pendency is up to 22.5 months across the core. And, you know, especially for patent term adjustments, as we talked about in one of the last panels, only in 2024, 32% of apps made the measure of 14 months to first office action. So, right, there was 32% of the applications that got their first office actions within 14 months. That number as of FY25 is 22. So by every measure, the office is doing worse under the new regime. So, yeah.
Is there any data on track one examinations?
Yeah, you can look at the patents visualization dashboard. If you don't have a link to that, just let me know and I'll make sure. Well, there's actually talk of getting rid of track one. So they've done it on the design patent side. You know, there is no expedited examination in design patents anymore, and there's talk of getting rid of track one on the utility patent side as well. They are holding to the numbers on track one, though. But even those, I think now with first office action on the merits, you want to keep your eye on when, because I think those numbers are going to go up too, because you just have a bottleneck. And like, I'll be honest, most supervisory patent examiners, and this is also my favorite typo of the administration, they have use or lose leave, right? You can only accrue so many hours and then you've got to use your vacation hours. Well, a lot of supervisory patent examiners take the entire month of December off. They actually got told in October that they can't do that. And any leave, any of their user, well, it said loose leaf, as in the paper, but which we'll talk about when we get to discretionary denials. Because what do you do if you're the one case like that has your case number and it's a typo? Anyway, but right, like, so they got told that they can't take any more, like using more than a week of leave in December would require a technology center director sign off and maybe the acting commissioner for patents sign off. So,
I'll also just note on the statistics, you should look at the statistics, but you should probably do it quickly because they have abolished the Patent Office of the Chief Economist, and at least a significant number of the dashboard things that used to be up there have gone away.
There's still ways to get to it. Some of us know the back doors.
Okay. Talk to Molly after. You can find out how to get the statistics the PTO is calculating and used to be providing. All right. So you mentioned, I mean, so it's interesting. So we're not, you did mention earlier, right, an increase in the production quotas effectively, right? Sort of like 6%
Absolutely.
increase in production quotas. But it sounds like that's being swamped by attrition or the kind of duplicative effort of the sort of additional reviews from primaries.
Yeah. I mean, well, and this is one of the numbers that you can look at. So the agency actually does report kind of the average tenure of the art units. And from last year to this year, the average length of time that an examiner is there, right, like, you know, average employment length, went from 16 years to 12 years this year. So with the fork in the road and with the early retirement and separation payments, the agency lost 902 examiners from March to August when they started being able to hire again. And you can see this in the report. So it's basically an 11% attrition rate for a core that used to only have a 4% attrition rate. You know, and you can even look on in the USPTO's own data. The average tenure of an examiner used to be closer to 20 years. Because people came in and they stayed and they liked it and they were valued. So I think that's one of the things that you want to keep your eye on because we really are just having many more junior people review applications. And that has an effect not just on the throughput, but it also has an effect on the quality. And so
And one other effect I will note, right, and this is the data is a little old, but Bhavin Sampath and I did a study on this, right, and found that the junior examiners in their first few years were actually much more likely to reject applications.
Oh yeah, they're terrified. They're terrified to make a mistake.
Maybe they're more, kind of like, more excited about the prospect. Maybe they haven't kind of learned how to like get to yes in the negotiation process. But for whatever reason, one thing about making the examining corps more junior means, I think, fewer grants.
Which, of course, is then the antithesis of, right, like what people are saying about the Squires administration being pro-patent, right? So I have figured out to put it this way. In almost every instance, the stated goal of the administration does not match the reality of the consequences of their actions.
If you do have an examiner who doesn't want to give you a patent, maybe one of the junior examiners who's a little too gung-ho, you can always just file a continuation, or you might have to file a divisional, right?
Sure.
Now what happens to the continuation?
It goes into a pool, and no examiner can pick up the continuation or divisional application. It gets assigned the date that you file it, and no examiner can pick up that continuation or divisional application until their docket is absent of any prior filed new application.
So just to be clear on what we just said, right? The continuations and the divisionals, right?
Uh-huh.
And the divisionals.
And continuations in part.
And CIPs are not going to be picked up kind of by the same examiner continuing in the course of a normal response. They go back to the back of the line and they go behind all the new applications, right? So that means when the examiner in your biotech art unit says divisional, you actually have 8 different patents here. We've reset the now 22, 23 month on average thing before we'll take a look at any but one of those.
Exactly.
Right. And similarly, if you want to file a continuation or a CIP, instead of doing it kind of with the same examiner at the same time, we're now kicking it back 2 years. And that might mean you have a different examiner. Because, of course,
most likely.
Yeah. Right, now that the attrition rate is turning over.
Yeah. Yeah, well, because, right, I mean, most of the people who left over the last year, and I think it will be really telling to see what happens in the December 31st, January 1st timeframe. I mean, I know I've signed 4 retirement cards in the last week for examiners because the older examiners who have their 20 years in are looking at this mess and saying, peace out. Right? I got my 20. I can retire with full retirement benefits. I'm gone. So you really, the agency really is losing its experienced people in rates historically unknown.
All right, so let's shift gears a little bit, right? We've been talking about the examining corps who are working harder, got more to do under tougher conditions. One group who I suspect, through no fault of their own, is not working as hard are PTAB judges. You have heard already today and yesterday about some of the stuff that's going on in the IPR process, but I just want to kind of like walk through a little bit the sort of set of things that's happened in the IPR process. So background to start with, right? We've had 19,000 IPRs in the 14 years since the AIA. The PTAB has done, frankly, an amazing job of keeping to deadlines, right? So examiners are supposed to get a first pickup in 14 months, but as Molly says, in a good year, that's 35 or 40%.
I was going to say that's always been a stretch goal.
Yeah, and now it's at 25%. The PTAB has never missed a deadline, right? Institution within 6 months, year to thing. The only case in which they have not made that was a case in which somebody filed bankruptcy and therefore froze the proceeding, which I don't think they can really be blamed for. And they've produced results that, despite sort of like made up fake statistics that you sometimes hear out in the world, have been for the last several years within 1% of the same results you get in court. So the actual ultimate challenger win rate in the PTAB depends on how you count partials, right? Where some claims are invalidated and some claims are kept standing, runs between 40 and 45%. The invalidation rate in courts is 43.1%. So it's a lot cheaper and you get pretty much the same ultimate results. What's happened in the last year is a kind of deliberate move, I think, to probably eliminate, but at the least very significantly weaken and cut back on.
Definitively.
On the IPR process. Yeah. So this starts with this discretionary denial idea, right? Discretionary denials in the last year, right, now have been somewhere between 75%, or if, like Jessica, if you're optimistic, right, or 97% if you're pessimistic of the petitions that have been filed. It depends on what's going to happen to the sort of remaining petitions. So how does this happen? First happens is this idea of settled expectations. If your patent has been around for a while, the PTO director declares, well, you have a settled expectation that patent shouldn't be challenged. The kind of baseline number that starts getting thrown around is 6 years. Now,
which where does that even come from?
Yeah, it's a good question, right? I mean, there is in court a latches provision of 6 years. There's a statutory damages provision of 6 years. There's a statute of limitations that'll happen after that. But you can always get 6 years worth of damages in court. So we don't say you didn't sue after 6 years, you lose your case. So one thing that's worth noting. 2/3 of all the patents, slightly less than 2/3 of all the patents, more than 60%, are more than 6 years old, right? 75% of the litigated patents are more than 6 years old, and more than 80% of the patents filed by non-practicing entities are more than 6 years old. So we've picked out a universe of all or almost all of the things we might actually see in IPR and said, these just don't get to count at all. And that's assuming 6 years is a real number, right? We've seen settled expectations applied to 2 or 3 years. We've seen arguments for settled expectations in post-grant oppositions, which have to be filed within the first 9 months after the patent issues. It's hard to say you've got a settled expectation in the first few months after your patent issues, but people are saying it. Settled expectations already knocks out a big chunk on discretionary denial before you get to the merits. Then you've got a required waiver, not just of arguments that overlap, right? There's an estoppel rule in the court. Required waiver of arguments that you could not raise in the PTAB, right? Arguments that I can't make in the PTAB, I must forego making in court, or we refuse to read your PTAB proceeding. I think that's pretty consistently at odds with both the statute and with the Federal Circuit's decisions in IO Engine versus Ingenico, which tell us here is the scope of the actual estoppel. But PTO says you want us to even read your petition, agree to give up arguments that the law says you don't have to give up. We will also, it appears, reject a meritorious petition, even if we decide it's meritorious, in part on the claims, if any of the claims of the patent would survive. And back when the director was actually writing short opinions, explaining himself, he explained that he was rejecting a petition that met the standards for institution because some of the claims would survive. That, I think, is pretty clearly at odds with the Supreme Court's decision in SAS versus Iancu, right, which says the standard is if even one claim is a challenge to even one claim is meritorious, then you've got to consider the whole, patent as a whole. There's a proposed rejection in the notice of proposed rulemaking. If anyone has tried to challenge this patent anywhere before and failed, then we won't take a look at it. You can see to some extent, right? I don't want a series of petitions, right? 3, 4, or 5 people file IPRs and they fail, and I want to add another one. But it's a little worrisome to say, you know what? I never had an opportunity to bring a claim, and now because somebody else brought a claim and lost it, I can't bring one. There's some suggestion in the rulemaking that this would apply even to ex parte re-exam.
Which, of course, is then contrary to what the Federal Circuit just said in Ray Gesture. This week, which is, right, like the re-examination statute does not provide for any involvement of the requester in the re-examination after the optional reply. So re-examinations can't count against the person who requested it because it's the office that maintains the reexamination proceeding.
And in fact, right, less true in the last decade or two since we've had the central reexamination unit, but it used to be the case, right, that the most common requester of an ex parte reexam was the patent applicant themselves, because they actually wanted to go bulletproof a patent, right, that was ready for litigation. So the idea that the patent applicant, the patent owner, could come in, request an ex parte reexam, get it, all right, get their patent confirmed, and then say, oh, now no one else can file an IPR because I myself have re-examined my own patent, strikes me as worrisome. That's all right. Wait for the microphone, please. Yeah.
Didn't they make an exception for that in the rulemaking?
No, not in the proposed rulemaking.
They described it, but
Yeah.
they used it as a reason for saying that that is actually an acceptable course of behavior and that the patent owner should have the ability to gold plate their patent and cut off other people from challenging.
So there's also, and maybe I'll kick this back to you briefly, Molly, on this. One of the things, the ex parte reexamination process has actually been working relatively well. People have been moving to it, right? Because in, I think, 2006, we created the central reexam unit, right?
2005.
2005,
Yep.
I was close. Right, and so whereas you used to go back to the same examiner who'd granted the patent and said, hey, do you think you made a mistake? We instead now send
Always
it to a
effective.
central reexamination unit, who were some pretty good and pretty
Well, they are the most senior.
examiners.
Right,
Exactly.
yeah. So
CRU going away?
Not quite yet. They've lost quite a few people. They're down one supervisory patent examiner in the CRU, so they went from 8 to 7. I believe that the number that left through Vera Visip and the Fork in the Road, they used to have 74 GS-15 examiners in the CRU. I believe they're down to 50. So their throughput is going to be throttled as well. So you're going to see those times start
and we're going to see, I
extending.
think, a lot more people shifting to ex parte re-exam if the IPR is not available. Right?
And then, and sometimes I think both Director Squires and Deputy Director Stewart say the quiet things out loud. In at least one meeting recently, Deputy Director Stewart has mentioned that she thinks it's a really good idea to put the CRU examiners on production, which will then artificially limit the time that the CRU examiner has to actually push the reexamination through what is going on.
All right. So
So-
there's more. The director has also told us that that he might reject an IPR proceeding because of the nationality of the filer. Right? There's hey, wait a minute, you're a Chinese company. Why should we, you're associated with the Chinese government. Why should we accept your application?
And it seems to be only China,
though.
though.
I think it is
Right, like I think it's only China because otherwise I would have expected him to bring in like the 371 list, right? Like the watch list of bad countries.
The question is that for actual submission of the application or?
This was an IPR, and yeah, so right, so
That's
yeah,
IPR.
This is all
We're
IPR,
still
right?
going to let them file patent applications,
Well,
though.
yeah, or
In big
that would
ways.
solve the backlog if we got rid of all the Chinese patent applications.
Well, but one of the interesting things, though, right, like that they also made to the examiner production is that patent prosecution highway cases are now only going to be counted for. So every patent application that gets filed gets 2 counts for the examiners, and it's divvied up based on what actions they take. The new performance agreement says that patent prosecution highway applications are only getting 1.75. So that means all of those applications from China that come through on the patent prosecution highway, the examiner actually has less time to examine those cases despite the language, I'll say the loose understanding of U.S. intellectual property law that exists in China about what they can and can't do here, which we see on the trademark side of the house. So right, like that baffles me as to why they would do that. If you were really looking at this, you would actually give the examiners 2.25 to examine patent prosecution highway cases, especially those that are coming from, certain
Where the
countries.
document is translated and there are other
Right.
kind of challenges.
Exactly.
All right. So, and then of course, as you have heard, the Director Squires brought all of the IPR decisions in-house to decide them himself, right? Taking the institution decisions away from the PTAB, right? Now, let's be clear, right? With the number of IPR petitions that have been filed and are pending, there is no way the director can himself evaluate all of these things on the merits.
He might have the Superman costume underneath his suit. I don't know. But not only that, but right, like I know one of the earlier PTAB panels said, oh, well, it's done in conjunction with 3 patent trial and appeal board judges.
It can be.
It can be. It doesn't have to be. And I think that's a key point.
And I think, I mean, so I have not talked to PTAB judges about whether they are kind of like doing the work sub rosa and recommending to him, but that's not my impression of what's happening. We don't know because one of the things he's done is decided not to write anything at all other than affirmed or denied about the petitions, right? So you get your petition goes to the director, director says denied. Now he tells us actually, I guess, discretionarily denied or denied on the merits. So you know that it was denied for one of the several reasons I just gave you, though you don't know which one, right? Or you know that it was denied on the merits, but you don't know why.
Well, and it may not even be your case. I mean, right? Okay, so they release the director decides that he's going to sua sponte, order re-examination of the Pokemon patent because he read, I think, an article that talked about the outrage that this patent was being enforced. So he goes ahead and he issues the press release on that patent and puts the wrong serial number of the patent on the press release. My understanding is that he actually ordered the re-exam for the correct serial number, but, we've already talked about 2 typos that have significant meaning in this talk from this administration. And so I just sit there and I go, if you're the person who gets your case discretionarily denied just by a number, and that number's wrong, you've no recourse. You're done.
The good news is that as we move to AI, the likelihood of hallucinations and number changes.
Oh, sure, that's going to go down. I'm excited about that.
All right, but so I want to know one final thing about this sort of this kind of no explanation issue, right? Which is he has actually instituted a few cases. I think it may be 6 now.
Is it 6? I thought it was only 4.
6.
6?
Some of which are post-grant oppositions. 2 PGO
Okay.
and 4 IPRs. So now, great news. You made it through the kind of 97% that have been rejected or are in limbo. You are one of the 3 to 4% that are that actually got granted. But you have no idea why. Neither does the patent owner. So now we go to briefing. Right? Institution has happened, right? The patent owner gets to file a brief in response to the institution decision.
I was right.
Exactly. What's it going to say, right? Yeah. Clearly, the arguments you didn't find persuasive for some reason that I don't know should have persuaded you. The petitioner then can say, no, we were right.
No, we were right.
We don't know what to brief because we don't have a claim construction. We don't have a sense of which grounds were considered valid, whether there are some claims but not all that are viewed as important. So we have no idea how that's going to work, but my estimate is poorly.
Sure.
Okay. All right. Now, finally, we got about 8 minutes left. Let me zoom out a little bit from the patent office to the sort of patent and the innovation system more broadly, where there's some other interesting stuff going on. A lot of this is more preliminary because it's coming from the main administration and not from the PTO, and Donald Trump has a tendency to say things and then they might or might not happen. But here are some of the things that the Trump administration has said we're going to do with respect to the patent system. First is we're going to ensure that the patent office gets a return on its investment in examining your patents. How are we going to do that? We're going to tax your patent. We're going to charge you a fee based on the value of your patent. So instead of paying whatever fee you currently pay to file a patent application, you would pay us a fee that was some percentage of the ultimate value of your patent if you get it.
Well, and this goes back to why I think, like, I query why the settled expectations are at 6 years. So the patent model or the financial model of the agency is that the agency doesn't actually break even on any application until the second maintenance fee is paid at 7.5 years. So what's to stop every patent owner who has a patent at 6 years from enforcing for a year and a half and then never paying the 7.5 and 11.5 year maintenance fees? If people decide to do that, the entire financial model of the agency collapses.
Yeah, I mean, presumably, if you want to sue in court, you're gonna have to have kept the patent in force, right? But
For a period
but
of time.
lot of people don't have to, right? That's fair.
What if you make all your money from the demand letters?
So I got two problems with the whole "we'll tax you as a percentage of your value," right? One is, well, maybe I have three problems. How many people, when they file their patent application, know how much money it will ultimately make over the 20 years? Feel free to raise your hand. Don't be shy.
Priceless.
Priceless. There we go. Right. Yes.
Worthless.
Worthless. Exactly.
There we go.
So that would be a logical thing to say.
There's someone who understands tax.
You get a free patent application, sir. If you litigate and I'm a defendant, I tell you I'm gonna come back and say, here's what they told the patent office the entire value of their patent would be. I am but one potential infringer. It can't. My damages must be less than that.
Absolutely.
Now, so you could of course pick a high number to avoid that, but then you have to pay a high tax.
Well, and what did you say when you valued your patent portfolio to the, I don't know, IRS?
Yeah, that's a good one. Okay, so 4 problems. My second problem, now maybe my third problem is, let's say you actually do give the real number and you think this is a really valuable patent. This is something I intend to enforce. Well, that means you got to pay a big number up front to file the application, right? Or maybe at the issuance date, right? Not after you've already collected royalties and revenue from this patent, but up front. Now, maybe you are rich and you can afford to do that, and your company has decided to spend a bunch of extra money on its patent system that it has not had to spend in the past. But if you're a startup or an individual or a company who's a bit frugal when it comes to their patent system, right? The idea that you might have to pay, we don't know exactly what the percent would be, but let's say, potentially for the really valuable patents, a 10x or 100x multiple of the current application fee seem in advance, and hope that you'll get it back on the back end seems like a bad idea.
Well, and I think your premise, though, Mark, is that it is the actual patent owner who's determining the valuation. I'm not sure that that's what the administration is thinking from some of the comments that have been made.
Maybe it'll be the office of the chief economist at the patent office that we abolished.
God, but we fired him. So no, but right, like, I mean, from what has been said, again, the quiet things out loud, is that they expect that patent tax to generate about $2 trillion into the U.S. Government's budget. And so that clearly means that they think they're going to be setting the valuation of those patents.
Or that, I mean, so the current office budget about $4 billion, right?
Yes.
Yeah, so, okay, so that's what, a 500x?
Something.
Yeah. Okay. So maybe on average you'll pay only 500 times for application fees what you do right now.
But the other part of that is when the government sets a tax and sets a value on something, you as a citizen of the U.S. as a U.S. citizen usually get the opportunity to appeal said valuation of what that is. So, and I will say this has not made me popular with my former Patent Trial and Appeal Board judge friends, but I have joked that they will become the Patent Valuation Appeal Board.
Yeah.
And they all look at me and there's a rude gesture that goes along with that.
I just want to note one additional problem I have with this, which is a broader systemic problem, right? Which is the idea that we are going to create a special tax just on innovation strikes me as uniquely dumb, right? If you want to raise $2 trillion by taxing corporate profits across the board, great, right? But if you were to pick a thing to impose a special tax that nobody else has to pay, innovation seems a really, really bad idea of a thing to tax. This is not, however, the only way in which you're planning to tax innovation. We have already announced, Trump has already announced, and I think actually started to implement this time, a 100% tariff on patents, pharmaceutical patents. So if you have a patented pharmaceutical and you manufacture outside the United States, we were imposing a special 100% tariff on you over and above other tariffs that might come from your country and over above any importation of a non-patented pharmaceutical. Right? Now, in theory, the result will then be I will negotiate with you, pharmaceutical company, to lower your prices in exchange for waiving this tariff. And we have one case in which that has actually happened. The Wegovy, Novo Nordisk agreed to cut the price of Wegovy in exchange for being exempted from the 100% tariff that will be applied to its competitors like Pfizer, right? So maybe you kind of negotiate your way around this, but again, the idea that we're going to impose a tax just on patented pharmaceuticals as a means of reducing the cost of drugs to US citizens strikes me as odd. We also want to tax university patents. There's a proposed 50% tax on university patents. And we might actually employ the march-in right against universities we don't like, particularly Harvard, and seize their patents and require them to be sort of like compulsorily licensed.
And to be clear, there's, I think, going to be a lot of hidden taxes. Like one of the effects of all of the maneuvers that they made in terms of personnel moves was, patent examiners were safe. So you had any number, and there are actually 5 technology centers that don't have an RQAS or a TQAS associated with them, the quality assurance specialists. They're gone. They went back to examining. So like the hidden tax that's part of all of the personnel moves that the agency has made is actually that quality is on you. If you want an enforceable patent, it's on you.
So that brings us, I think, to like where we're going to close, right? Which is the sort of, if we think about sort of like why you should care, right? There are some of these things, right, that if my interest is just prosecuting patents, you might want to celebrate, right? A lot of patent owners are happy to see the IPR process go away. I think that's a little short-sighted because what they're going to see is more litigation at more cost and time. But I understand why they're like, hey, there were ways my patent was being invalidated and now it doesn't. But I think as you look at the sort of broader ecosystem, right, even if your interest is only, I want to get as many patents through the office as possible, as cheaply as possible, you should be worried about, am I going to be taxed, right? Is the backlog going to increase? Can I not file continuations and divisionals and get them examined in a reasonable period? And then I think maybe we should worry about the people.
Yeah, well, and we go back to the people. Like, I really do think, right, once we get to the point, so, right, a lot of the PTAB judges have been shifted over to ex parte appeals. It looks like, I mean, if the numbers are right, the ex parte appeal inventory is going to be 0 in June of 2026. If that's true, you have this massive reduction in the number of post-grant proceedings that the judges have to do, and you have a 0% inventory of ex parte cases that they can work through. The agency is going to be forced to right-size the Patent Trial and Appeal Board. I mean, they've lost 19% of the judges already over the last 9 months. I think that you could very well see a reduction in force at the Patent Trial and Appeal Board, depending on, again, how many people retire. We're getting to the end of the year. Most federal workers who have reached their 20-year will wait until the end of the year. There's a couple of really tax beneficial things for the employees. So, another thing to keep your eye on over the course of the next several weeks is, how many more people are retiring from the agency, both in the examining corps as well as the Patent Trial and Appeal Board.
All right, Wayne promised that Molly and I would disagree with each other. I don't think we did, so we failed you, and we apologize, but we are out of time. Thank you for listening.